Okay, so welcome everyone. My name is Dave Kubikian from the Herzog Law Firm. I'm an estate planning and elder law attorney. Our offices are located in Albany, Saratoga Springs, Clifton Park, and Kingston, and our reach is kind of all of New York State. So if you have friends and family who you think may need a talking to, I'm more than happy to provide that talking. We've done a number of webinars this year. It's been the year of the webinar due to the pandemic. And I think this is one of the things that we'll end up keeping in future years because it's a really nice, easy way to reach people without having, to all get together in a room, although the cookies and the coffee is always nice. And it's personally, I get a lot of energy from seeing people and feeding off of them and answering their questions and also seeing their faces to see if what I'm saying makes sense and is connecting or whether I need to slow it down or speed it up and so on. And that kind of gets lost in the webinars. You do have the ability to chat with us and ask questions as we go, and feel free to do that. And you could also email us. You can go to our website, you can call us, and the numbers are below on this first slide. So this webinar is called Wills versus Trusts, and it's my favorite webinar. Don't tell the other webinars I've said that, but it's my favorite because it gets to the heart of it all, right? The two main ways to do what we call estate planning is wills and is trusts. And there's a lot of bad information about them. And the idea behind this, the goal of this webinar is to kind of clarify what does what, and you'll see there's a lot of overlap between the two. You'll see that they're both car washes, whatever that means. You'll learn as we go. And they're all incredibly useful. There is no wrong answer for people as to whether they need a will or a trust. The answer is you need to get information about them, make a good informed decision, and then off you go. So let's get going on this. Let's start with an estate plan. So what is an estate plan? Everyone's got to have an estate plan, right? That's what they say. There's probably 60% of the population that doesn't have any estate plan or formal estate plan. In my opinion, it's something everyone 18 or older needs to have. That's not because I happen to make a living off of people doing estate plans, although that happens to be nice. It's because at any age, 18 or older, we can become incapacitated. I mean, we get incapacitated at 16 years old, but we have parents, right? We have guardians. 18 or older, we're on our own, and absent some formal planning, there's no one in place who can sign for you, who can speak for you, who could talk to doctors on your behalf. There's no fixed determination as to, who's going to get your assets one day other than you having some sort of estate plan. One of the other reasons why we like estate plans is they could help us avoid things like guardianships. They can keep costs down, which is kind of counterintuitive because people pay me money to do an estate plan, and then I talk about costs being lower, even though you're paying off the bat. And that's because of things like avoiding probate, which we're going to spend a lot of time on. Over time, your estate plans change, and what's good in 2020 may not be good in 2030, and so on and so forth. In terms of the most basic of estate plans and estate planning, it's all about power of attorney, a healthcare proxy, and a last will and testament. Now, there's other documents. There's things like disposition of remains forms, which is as lovely as it sounds, and things like living wills. At our firm, we insert the living will into the healthcare proxy. But this is your basic plan, and I call this your basic car wash. And I've been using the car wash analogy quite a bit recently. I'm not sure if it fully works. Feel free to chime in and say to lose it or to keep it. But the idea here is that I need you guys to have a plan, a result. What happens after your death? Because in fact, that's what estate planning is. You guys don't have an estate right now, and I'm happy you don't, because it means you're on 2 feet. It means you're still alive. Your estate exists, maybe. But the prerequisite is you got to be dead to have an estate, right? Estate planning is planning for who gets what. The analogy is like a car wash. If we go to a car wash, there is a basic car wash you can get. And I guarantee you, if you purchase that basic car wash, guess what? Your car got washed. And in my world, the basics, right? The bottom line is who gets our things when we're no longer here? When do they get it? How do they get it, right? And those rules on who gets what, when do they get it, how do they get it, that is the car wash. And at a minimum, whatever documents you use to complete your estate plan, they will result in that car getting washed, right? Mission accomplished. As we'll learn, there's more efficient ways to do it. There are other humongous considerations that you're going to need to take. And in my opinion, all roads will eventually lead to trust, but that's not always the case. In terms of the basic estate plan, we're talking about powers of attorney, healthcare proxies, wills, and a couple other documents. In the case of a power of attorney, we're picking people on sunny days to help us out on rainy days. And those people are called our powers of attorney or our agents, or sometimes attorney in fact. The job of the agent is to do whatever you tell them to do. And then, of course, if you're incapacitated down the road, to do things that are in your best interests. Even though you may be married, your spouse does not have the right to sign for you. Everybody needs to have a power of attorney. A lot of times people say, oh, wait a minute, hold on. I can sign a check, my wife can sign a check. That's great. You know why? Because both of you are on the bank account, which means both of you can sign to get things done, which helps alleviate the need for a power of attorney, sure, but you cannot sign for each other. Absolutely not. You're signing as yourself. You happen to be an authorized signatory. When you're using power of attorney, you are the principal, the person who gave you the power. So if you got to go to the bank to make a deposit or a withdrawal, if you need to pay a bill, you are acting as the principal, okay? In terms of powers of attorney, they become incredibly important because we're able to give our agents some really heavy duty powers, including the power to kick the can down the road and create trust in the future and move assets around in the future when it's in our best interest to help us qualify for different things, kind of like for long-term care, which we'll get into. For those that have done a power of attorney in the past, it's important to have a good recent form, because the last thing we want is for some bank teller to get your power of attorney and say, well, I got to send this up to corporate and wait 3 to 8 business days. That's not the point of the power of attorney. It's in an emergency, breaking case of emergency, we can break that glass and transact and do whatever we need to do. In the case of a healthcare proxy, it's a little more basic, I guess. It's all about healthcare decisions, and we divide that into 2 categories: regular non-end-of-life decision-making, and that's where the healthcare proxy comes in. You're naming people who can speak for you, who can reflect your wishes in terms of your healthcare. There's also something called the living will that we combine with our healthcare proxy here at Herzog. It confuses people because it has the word will in there, and I wish it didn't. But a living will helps with end-of-life decision-making, particularly when the end is irreversibly near, because at that point, the ship is sinking. Let's make things as pleasant as possible. Let's keep playing have the string quartet keep playing on the Titanic type of thing. Okay. In terms of a will, well, it's a really important document. I'm going to talk on both sides of my mouth. I'm going to tell you how important it is, and then I'm going to tell you why you really don't want it to be the only reason things go to the right people, and why you may not want it to be the largest piece of your estate plan, but it is incredibly important to have. Wills take up different varieties. They could be super duper complicated. They could be a quote unquote simple will with very complicated provisions. They could be something called a pour over will, which we use whenever we do trust planning. The important thing for you guys to realize is that a will is a wonderful way to get a car washed. Okay, you want to get a car wash, go get a car wash. You can get the exterior only, done, right? Car is washed. You need a will to reflect where your things go, done. However, there's more to the story. There's more to consider as to whether the will is the right move for you. It's a document that most people will say, if we were playing Family Feud and we said 100 people surveyed, top 5 answers on the board, how many people, what percentage of the population have a will? You'd probably hear a large percentage, but the reality is a relatively small percentage actually has their wills in place. And it's kind of ironic because people will say, I don't really want to think about death, and I'm not ready to have that discussion. But those very same people have life insurance. Why do they have life insurance? They have beneficiaries on their retirement accounts. Why'd you name a beneficiary? It's not because you're going to live forever, but for some reason, wills and more formal estate planning tends to take a back seat when it comes to planning. The will, in terms of how it works, will have beneficiaries, those people who will receive things upon your death. And when it comes to beneficiaries, it could be as complicated as you want. You can have things held in trust for them, and you could say that there are certain hoops people need to jump through or attain certain ages before people get assets. You'll name an executor. That person's going to make sure whatever your will says happens. Their job is pretty straightforward. And in general, for your will to mean anything, I mean, it's just a piece of paper. For it to mean something, we need to go through something called probate. Probate is the legal avenue for making your piece of paper that says last will and testament be reviewed and adjudicated by the courts to be, in fact, your last will and testament. That probate process is a bear. The problem with probate, there's a couple fold. Number one, it's not very efficient. Okay, there's going to be court filing fees. There's going to be attorney's fees involved in the process. A normal probate at our firm will take about a year. That doesn't mean we can't do anything for a year. It just means beginning, day to death through, we're done with all of this. It's probably a year. That being said, we do have estates from 2015, and it's 2020 right now. Okay, I don't want to scare anyone and make you think that every probate's going to be years and years, and every estate's going to have a fight. That's rare. That's more popular on TV than it is in actual practice. But the problem with probate is that even when things are pretty straightforward, even when things are just everything going to a spouse, the process itself can take a very long time. The filing fees are still going to be there. The attorney's fees are still going to be there. In terms of a valid will, there's certain execution requirements, and this is where I sometimes go off on a tangent about websites that say they can do your estate planning for you. I also have a technique for you to remove a tooth. You may not want to take my advice on that, but when it comes to wills and trusts and so on, it's really important to use a professional. It does not need to be a professional at Herzog Law Firm. Okay, there's a lot of good people out there. Your will needs to have two witnesses. They need to be disinterested, and they can't be your pets. I don't have any clients that have ever used their pets. I just think it's funny to say that. Those witnesses will be called on down the road to testify as to your capacity and make sure everything was done right. Oftentimes, the witnesses will sign an affidavit prior to that death. They'll usually sign it at the same time they're signing your will as a witness. Can't have any handwritten changes. A lot of times people come in and they have little notations and changes they want to do, and they think that by initialing their will, they're accomplishing, instead of giving 15 grand to someone, they lowered it to 10, mission accomplished. Don't do that, okay? We want to change your will wholesale. There are such things as codicils, which are amendments to wills. We don't like those either in practice. That's technically an amendment, but the amendment's only as good as the original, meaning that upon a death, not only do we need to show everything was signed the right way for the original will, but that also all of these requirements were there for the codicil as well. And a lot of times it's just easier to do a new will, same price. If you don't have a will, right? I keep talking about having a will, have a will, have a will. If you don't have a will, there is a statute out there that says what happens to your assets. It's called dying intestate, and there's intestacy laws. For the most part, they make common sense. It's about things going to your bloodline. If you die with children and no spouse, as an example, everything goes to your children. If you die with no children and your spouse survives you, everything goes to your spouse. Again, seems to make sense. No spouse, no kids, no grandkids, everything actually goes up to your parents, and that's where a lot of trouble starts. No parents, brothers and sisters, then nephews and nieces. If none of that, grandparents, and over to cousins and so on. So it's not common that your estate will go to the government. which is what happens if we have a very barren family tree. It's far more likely things go to the wrong people that, if you had your way, you wouldn't have left things to. There's no charitable distributions when it comes to laws of intestacy. There's no friends getting money. There's no alma maters getting money. There's no rules as to how people get money. There's no, hey, you know what, that's a 5-year-old that's about to get money. Let's not give them money until they turn 30 when it's a little more appropriate. They're going to get it at 18 and they're going to blow it. So I don't want you to rely on these laws, although it's important to know they exist. When it comes to probate, and actually, you know what, I'll go back to this intestacy slide for a second. The people who would get, if you don't have a will, are the people who can contest your will when you do have a will, right? The idea in contesting a will is I would get more if this thing didn't exist. I'm adversely impacted by this thing. I should be getting more. Well, you should be getting more. That's determined by what New York State would say if there was no will. Okay. Sometimes you could fight a will because you were getting more in a previous will as well. So I said to you earlier, I'm going to talk on both sides of my mouth, and I am a man of my word. So while I really think you should have a will, I'm going to say to you, ideally, I want no assets to pass through the will. I want you to have what's called non-probate property. Non-probate property are assets you own with beneficiaries, or assets you own where you are a joint owner with someone else, and there's something called rights of survivorship. And the idea here is that if I have life insurance, right, and my wife is my beneficiary, if I died right now, we don't need to look at my will to see where that life insurance goes. It goes to my wife because she's the beneficiary. Same thing with retirement, right? Same thing with real estate. If you own a property, join with rights of survivorship, which is how it works when you have property with your spouse. We're going to avoid probate with that property. In fact, if I died right now, except for if my coffee here was poisoned, if I died right now, okay, everything would go to my wife. And that's because of the way things are titled. That's because the fact she's my beneficiary. We would not need to look at my will. We would not need to look at my trust, okay? Pardon me. Now, that's great. It's great to avoid probate, and I often say we get one free death when it comes to a spouse. I also have a weird sense of humor. But if you called my wife and said, Dave died again at one of his webinars, and she said, oh my goodness, and she died right there, then we're going to go through a probate for her because she doesn't have a spouse. Hopefully she didn't remarry so quickly. There's a catch, though, with non-probate property, because a lot of times people come in and they say, well, you know what, I don't need a will yet. Everything is joint with my spouse. We're both young. Chances are nothing's going to happen. And if anything did happen, right, everything's going to go to our kids. That's a problem. And that's a problem if your kids are young. Let me give you myself as an example again. So when I do seminars in person, I used to say to people, I'd lay it out. I'd say, wife, I have 2 kids. They're 7 and a half now and 1.5. And I'd say to you, all right, my wife is my beneficiary on my life insurance. Who is my backup beneficiary? And I'm kind of setting you up because most people will say your kids. In which case I say they are 7 and a half and 1.5, right? That's kind of the worst idea in the world. And the negative that comes with this non-probate property, at least the ones where we're relying on beneficiaries, is there's no rules to who gets money and how they get it and when they get it. It's just a name and a percentage. You guys have filled these beneficiary forms out before with your employment, life insurance, with just opening up an account at the bank. I can't list my kids as beneficiaries on assets because there's no rules that say hold money and make sure they go through school and make sure that they don't blow it on rims for their car when they're 18 years old, right? I need, even though they're an adult at 18, they're not an adult at 18, you know that. I wasn't an adult at 18. I don't think I was an adult at 25. Anywho, less about me. So how do we do this, right? How do we avoid probate? Because probate's so bad, right? Well, it's not the worst thing in the world, because if that's where all the rules are, if your estate says your will says I give everything to my wife, and if my wife predeceases me, I give everything to my kids, but as follows, hold it, a little bit at 22, more at 25, everything else at 30, and so on and so forth. Well, that's a pretty good plan, right? That's a good car wash, guys. That gets the job done. And so sometimes I'll tell my clients, especially the younger ones, hey, you know what? Keep your wife as beneficiary on your life insurance, but you know what? Your backup beneficiary, I know it sounds weird. Name your estate, the estate of Dave Kubikian. You guys shouldn't name the estate of Dave Kubikian. I should name the estate of Dave Kubikian as my backup. So that way, if my wife predeceased me and there's a pile of money, it's going to go to the place where the rules are, because the will had all these nice, eloquent rules as to when my kids are going to get money if my wife and I weren't around. Okay. That's not perfect either, because now we're deliberately going through this probate process. We're deliberately going to face filing fees and attorney's fees and this whole probate process that's going to be supervised by the courts. So where do we go from there? Well, if you look at the very bottom of your page, we look at trusts as a happy medium, a way to avoid probate while having rules. So let's talk about trusts. What is a trust? That's great. Trust is a box, or it's a cup of coffee, right? And the rules as to how you put things in and how you take things out of your cup of coffee is determinative of what kind of trust you have. There are two main kinds of trusts that I deal with. One is called a testamentary trust. The other is called a living trust, or an inter vivos trust. A testamentary trust is a trust that is in your will, in your last will and testament, thus testamentary trust. And those are super common, right? Everything to my wife, then to my kids, not until a certain age. Boom, right? That's a testamentary trust if my wife predeceased me and my kids survived me and they're below a certain age, hold it in trust. And obviously that's one sentence real quick. Couple pages in your simple will can contain a testamentary trust and have all the bells and whistles that are appropriate. The problem with testamentary trust, it's, again, gets the car washed, right? But the problem with the testamentary trust is that we got to go through probate. We got to have that will actually mean something, actually be probated to be your last will and testament before those words in said will mean anything. A living trust, is a trust you create today. It exists today. We're not waiting until your death and probate for the trust to exist. You're creating it today, the box today. And that takes a couple different forms, namely revocable and then different kinds of irrevocable trust. In terms of revocable trusts, and this is where sometimes I lose people, and this is where I really wish we were in the same room together. The words revocable and irrevocable, have different meanings to different people. There's the actual meaning, the actual legal definitions, which I'm going to focus on, but then there's what you think it means. For example, I'll give you a great example of how this works. So ever and ever, I would hear people say that I'm just going to peruse this. They'd use the word peruse. The word peruse means to look at very carefully, but when you use it in language in a sentence, you're typically saying, I'm just gonna peruse it. Revocable, irrevocable, similar, because people, when they hear the words irrevocable, they think things like you can't change it, you can't control it, you can't revoke it or undo it. And that's not actually true. You could do all those things even with an irrevocable trust. So I'm going to try to retrain you guys as to what these two words, revocable and irrevocable, mean, and I think it's going to help us. Okay. So what a revocable trust is, what revocable means is that the person who created the thing can undo that thing by themselves. That's what revocable means. So if I created a revocable trust, right, myself, I, by myself, can revoke it. I can undo it, okay? Has nothing to do with changing the terms, right? That is not a revocable concept or irrevocable concept. It has nothing to do with control. That's not an irrevocable or revocable concept. Revocable literally means you, by yourself, with just your signature, can do something, okay? So in the terms of an irrevocable trust, right, you are the grantor, the person who created the trust. Sometimes you're called a settlor. But you create the trust, and you're going to name someone to be trustee for your revocable trust. Typically, it's still you, okay? And you're going to have beneficiaries for that trust, both beneficiaries during the existence of the trust, during your life typically. So that may be someone called an income beneficiary. And then also your trust will have a beneficiary who gets assets one day when this trust ends. Kind of like who gets my money from my will, who gets my money from my trust, right? The end of the day beneficiary. Because it's a revocable trust, you as the creator, as the grantor, can undo this thing whenever you feel like it, right? If there's money in the revocable trust or there's money in your personal bank account, there's really no difference between the two. When it comes to revocable trusts, it's, you know, for tax purposes, everything's listed under your social security number. There really is nothing that stops you from walking into the bank and opening up a account for your revocable trust and then moving money freely from that trust to your own personal bank account. You're going to name backups as trustees in case you become incapacitated, in case one day you pass away, so that that backup can continue the administration of the trust or even terminate it and start giving things out to different people. In that case, the trustee is taking the role of an executor, if we were talking about a will. Okay. The purpose of revocable trust in general, right, where I see it the most, where it's the right fit for my clients, is when we're trying to avoid probate and we have some complications. We don't want to go through probate. Perhaps we have a second marriage with children from prior relationships. Maybe we're just young and we're not ready for the other kind of trust we're going to be talking about today, which is more towards long-term care. And we just, you know, we have property in a couple states. We really, really want to avoid probate because that might be a little messy. Okay. Excuse me. What revocable trusts don't do, right? They avoid probate, right? So in my car wash analogy, revocable trusts are now we got some sort of package where they're using a wax or something, right? A little more protection. We're saving a little money, right? It more benefits to us, more features, more expensive than the outside only car wash, the will, right? But at the end of the day, remember, they're both going to have the same rules as to who gets your money, when they get it, how they get it. They're both getting the car washed, just a little different, right? Our needs may be different, our wants may be different, so we're changing the type of plan we have. What the revocable trust doesn't do is it doesn't help protect assets, particularly when we're talking about long-term care expenses we may have. And that's where we get into another kind of trust. It's a form of irrevocable trust. We call it a Medicaid asset protection trust. Okay, we do have a couple questions. I'm going to attack them a little later, guys, because they have to do with some topics that we're going to be covering later on. But thank you for those questions. Keep asking them. Okay. So, revocable trusts mean you, the creator, can, whenever you feel like it, with just your signature, pull everything out of the trust and revoke it if that's what you wanted to do. And that's not going to help us beyond avoiding probate and dealing with some funky family back patterns. The reason why requires us to look at Medicaid for a second and look at long-term care. So let's just shift gears for a second, and let me just say we have whole webinars that myself or Jane Marie, Debbie, Harry have done both this week and in the past, and you could access them on our website under herzoglaw.com under the blog page. Whole webinars just about Medicaid, right? So I'm going to just take 2 minutes here to talk about it. We get older, we have long-term care needs. We don't have a memory anymore, or we can't get across the room anymore physically. We're in the world of long-term care. These are things that aren't going to get better. It's an expensive world. And the way that most people will pay for that world is they're going to private pay until they don't have enough money to private pay, and then they'll qualify for Medicaid. And Medicaid, in their regulations, provides that you don't have to spend all your money. Like literally, they say if you've planned within 5 years plus, and move things around 5 years plus, those things that you put into a trust, for example, could be exempt from being considered by Medicaid to be your asset. You won't have to spend it down. However, what they're looking for when they do evaluate your qualifications is they're looking specifically at those assets that you, with just your signature, guys, right? What you with just your signature can get, what you can put into your pocket. So they look at things like your bank accounts and your CDs and your savings bonds. They look at your brokerage accounts where you could call someone and say, buy, 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 sell, 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 whatever. They look at cash value in your life insurance. They look at things like Roth IRAs. They look at your home, because you could sell your home if I had the right amount of money in my pocket, because you could do those things with just your signature. Now, with the IRAs, right, it's just Roth IRAs that they'll count against you. In general, they'll exempt other kinds of qualified retirement plans. But the idea is if you can get to it by yourself with just your signature, and if you see where I'm going, that sounds a lot like the revocable trust, because for revocable, we can get to what's in that with just our signature, right? So that's not going to cut it. But we know what Medicaid cares about. We know what they look for. They look at what you can get with just your signature. So our goal is to plan now, plan 5 years ahead of time without a crystal ball. We got a plan for when you're going to be older, maybe even decades older. And the idea is, well, am I really going to need a nursing home? No, the vast majority of people will not need a nursing home, but people do, and it's really expensive. The majority of people, especially if you live long enough, you're going to need long-term care, but maybe that'll be at home. But still, there's a Medicaid program for that too. It's something we're going to need to prepare for. But gee, wouldn't it be nice if we could prepare in a way where we still use and enjoy all of our assets, and life's kind of the same, and we still control everything? And that's where this Medicaid Asset Protection Trust comes in. It is, again, a form of irrevocable trust. People say to me all the time, is this trust irrevocable? And I cannot just say yes, because I know where they're going. They're thinking irrevocable, I can't change it, I can't undo it, I can't control it, I'm giving up control for something that may never happen. That's not what this trust does. Okay, so what this type of irrevocable trust, a Medicaid Asset Protection Trust, does is it protects our assets. And the reason it does it is because we make it so you're not the trustee, and we make it so that you, the creator of the trust, cannot by yourself pull everything out of the trust whenever you feel like it. Now, people say to me, well, hold on, you just said we can't undo it, right? We can't revoke it in the lowercase r revoke. We can't undo it. We can't pull money out. That's not what I said, right? Roll back the tape, right? I didn't say you can't do it. I said you can't do it by yourself, because that's what Medicaid cares about. So what we do, right, we set up this trust. We call it well, it's actually not even called the Medicaid Asset Protection Trust, but we refer to it as that. That trust will not have you as a trustee, excuse me. It will not be you or your spouse as trustee. It could be your kids, it could be a stranger, it could be a neighbor, a brother, a sister, whatever you want, nephew, niece. That trustee is the signatory for the trust. That's what a trustee is. Factually, we need that signatory to sign when money's going to come out. Okay, so far we check the box, you by yourself can't pull out your money. Other people will say, well, now wait a minute, if I got to ask permission of my kids to use my own money, that's not the kind of life I want to be living. You don't have to do that either. Did I say that? No, I didn't say that. Roll back that tape. What I said is we need the signature of the trustee when we're going to pull money out. In fact, we'll require the signature of the trustee and the beneficiary, the way we do things, the beneficiaries of the trust. But we're not asking permission from anyone to do these things. The reason why is because in our trusts and trusts of other firms that are, my colleagues at other firms, what Medicaid is okay with is the idea that you, during your life, even though it's an irrevocable trust, you have the revocable ability, whenever you feel like it, with just your signature, to amend your trust to change who the trustee is. You can fire the trustee, replace them with whoever you want. And you can amend your trust to change your beneficiaries. You can fire your beneficiaries and replace them with whoever you want. So let me get through a couple slides and then I'll give you another analogy and see if it works. So the idea with the Medicaid Asset Protection Trust, and I should tweak this slide to say this isn't for all irrevocable trusts, it's for this trust. We have an audience of one. We're concerned with just Medicaid and them not looking at the things, the contents of this trust as being your resources. We don't want them to make you spend it down. So we create a trust where you're not the trustee. Ideally, 5 years go by, and when we do, if we do need to apply for nursing home Medicaid, we know that we're past the look back, and whatever's in that trust and whatever it's grown to and been in that trust for 5 years is protected. A couple features of it, right? You can't be the trustee, but your family members can. You are the income beneficiary of the trust. We put things like houses into the trust, just like we would with the revocable. You can get principal distributions from the trust with a couple signatures. Automatically, you don't get principal distributions, but you can get them if you want them. You control when you get them. You can reserve the right to change your trustee. And in fact, you do reserve the right to change your trustee. You could also change who gets your assets one day when you die. And going back to the car wash analogy, the idea here is we're setting up an entity that gets things to the right people at the right time, right? The way we want when we die. But because we don't have to spend down those assets, we're saving a lot of money. There's going to be a lot more money in your estate, in your trust, to be divided to whatever, whoever is important to you. When it comes to avoiding probate, and I kind of skipped this, I should have talked about it a little more when we talked about revocable. We put homes into your trust, revocable or the Medicaid trust. And the reason why we do is because you are still going to be responsible for all the home expenses, like taxes and insurance. You're still going to be having exclusive use and occupancy of the property, a legal life use, if you will. And what that'll mean is that we're still going to get star exemptions. We're still going to have deductions when it comes to real estate that's in our name. If we have rental properties, it's kind of the same thing. Whether it's a revocable trust or the Medicaid Asset Protection Trust, we're going to not have a trust paying taxes. You guys, the individuals, are still going to pay taxes as if you always did. If we put investments into either of these trusts, you're going to pay taxes on those gains from those investments like you always did. These trusts have an audience of one. In the revocable trust, it's to avoid probate. In the irrevocable Medicaid Asset Protection Trust, it's all about protecting assets for our long-term care needs, not other things. So we're going to keep all the good tax consequences that exist in life. We're going to get rid of all the bad ones. We're going to keep that star exemption and so on. The analogy I like to use when it comes to irrevocable trusts is it's like a restaurant. And if we say Medicaid cares if you can operate your restaurant by yourself, right? If you can get something by yourself, that's what they care about. In my restaurant analogy, it's, can I operate this thing by myself? Of course you can't. It's a restaurant, right? We need cooks and we need servers, we need hostesses, we need people to order the food, we need people to accept shipments of lettuce and God knows what else, right? So if you did own a restaurant or you did want to start a restaurant, it's not a great time for it, but if you did, you can't do it by yourself. What are you going to do? You're going to hire a general manager to help you out. That general manager is like a trustee. Okay? They have some authority, but they work for you, right? If you don't like them, you get rid of them. Whose restaurant is it? It's your restaurant. Who gets the money if you made a lot of money on your restaurant? You guys do, right? So it's all the same. And if it sounds like I'm spending a lot of time on this whole irrevocable, revocable distinction, it's because I have to, because there's so much bad information out there, because people hear irrevocable trust and they think other kinds of irrevocable trust that are a little more restrictive as to your use and enjoyment. I tell my clients, I don't like giving up control ever. And I don't recommend my clients to. And thankfully, this Medicaid Asset Protection Trust allows our clients to retain control. Guess what? You could pull all your assets out of the trust if you feel like it. Now, do we put everything in your trust? Of course not, right? We're going to have a lot, tens of thousands of dollars outside the trust in your individual names. Use and enjoy. If you're planning on big trips when the world opens up again, go for it. Spend your money, right? We could leave enough money out of the trust, or we could, whenever you want, have money pulled out of the trust. There's no ongoing annual fees for the trust, either kind, that I've talked about today. Now, I will also say there's other reasons to do trusts that get into estate tax planning, or get into, we're worried about creditors, or we're worried about our business and so on. That's a different conversation, okay? A couple highlights about the difference between trusts and wills. And remember, car wash, right? You do a trust, it's a higher level of car wash. You do the Medicaid trust, now we're cleaning those tires, we're doing undercarriage stuff. And why are we doing it? Well, because we need that protection, or we might need that protection. But you better believe it includes all the benefits of all the other kinds of plans you could do that are quote unquote lesser. So it's all going to get the job done. And over time, my experience is that people go from the will to eventually maybe a revocable trust to, again, eventually a Medicaid Asset Protection Trust or something like that. Okay. You can't leave here thinking I need a trust. You can't leave here thinking I need a will. You got to leave here thinking I got some stuff to think about, and I probably need to talk with Dave or Jane Marie or Debbie or Harry or even another firm about that stuff. It's that important, okay? Highlights. We're going to avoid probate when it comes to trusts, as long as we fund it properly, that is. We are getting the job done. The car is getting washed with this trust, but it's harder to contest. It's private, okay? When it comes to wills, and these seem like negatives, and they happen to be, but wills are really good. They get the job done. I can't emphasize that enough. But we do go through probate. That does involve costs. The language in it, the trusts that are created in it, only matter after death. It doesn't do anything for during our lives, okay? It's all post-death. In terms of what's right for you, there are some general benchmark things I can say that I feel pretty confident in saying, and it's not about your particular fact pattern. I can say, for one, if we were walking down the street and there was a will sitting here and there was a trust sitting there, and you could pick either one up and there you go, you're all set. Everybody is picking up that trust. If a will and a trust were the same amount of money, you're doing a trust every time. Why? Because we get to avoid probate, okay? However, they're not the same amount of money, and it becomes a business decision that I shut my mouth about. Okay. When we have complicated fact patterns, that doesn't mean we have to do a trust, but maybe the marker is a little more over on the trust side. We could do a lot with even a basic, simple will. Okay. The times where I really think a trust is going to be appropriate is when we have lots of parcels of real estate, particularly when we have property in multiple states, because the way it works, it's not just a probate in New York, it might be a probate in New York and Florida. I have a client that I saw today, a property here and a property in Houston, Texas. So let's avoid probate in both, the Lone Star State and New York. When we have business assets or we have other reasons to avoid probate, like creditors, a lot of times people say to me, you know what, I qualified for Medicaid, or I got my mom qualified for Medicaid, but I don't need a trust, or I don't need to do any advanced planning. Well, guess what? Medicaid's going to put a lien on mom's estate one day when she passes away. And her estate is her probate estate, what's going through the courts. So if we have a trust or we avoid probate through a beneficiary designation, we could avoid those liens. Obviously, when we're talking about Medicaid, Medicaid Asset Protection Trust is going to make a lot of sense as well. If we're anticipating a fight, we're not leaving things to all of our kids. Trust, okay? You're opening up the door to litigation, because you're literally, the state of New York is going to give an opportunity to all the people who would have gotten more if there was no will. It will give them the opportunity to contest the will, which we'd like to avoid. We are on the radio Saturday mornings, and it replays on Sundays. It's 8 a.m. to 9 a.m. on Saturday mornings on Magic 590 and 100.5. little further north, it's 1410 AM and 96.9 FM. It's also replayed on WBPM a couple times, actually, in our Kingston, Ulster County, Dutchess County market. We'd love for you to listen to that. We do free consults. We do free 1-hour consults, actually. I don't know if anyone else really does that. We do lots of Zooms these days, lots of phone calls, and we are doing in person. We take your safety and ours very, very seriously. So everything's wiped down and so on and so forth. I really appreciate you guys joining us. I know there's a couple of questions that I'm going to get to right now, but I do want to emphasize, please don't leave here thinking, I need to do a trust or I need this or that. These are all things being equal. All things are never equal. And the details of your fact pattern matter tremendously. So a couple of questions here. I can get to it. So one of them was, when applying for Medicaid and you are legally separated, not divorced, how does that work? Does the spouse have any claim to part of the assets? So you're kind of mixing some things here. So the concern I have when we have legally separated clients is whether or not Medicaid is going to look at the assets or income of that other spouse, particularly if my client is the other spouse. But you said legally separated, and that means that there's a legal separation agreement that likely waives certain support rights, likely waives estate rights, certainly, that one may have in the other. So if it is a legal separation, that should probably not complicate the Medicaid application that much. Make sure that your beneficiaries have been updated to reflect this legal separation. Sometimes we have people who still have an ex-spouse as a beneficiary on an account here or there, and that's a problem. Okay. Does the spouse have any claim to part of the assets? Well, they shouldn't, because in the legal separation, they're waiving their rights to certain assets. And again, my first thought is always going to be, can Medicaid disqualify me because of my spouse or a spouse that I'm separated from? I've had situations where we have spouses who are not legally separated, they're informally separated and have been for decades, and that's not enough, right? We need to do planning, otherwise Medicaid can go after the spouse. Another question about home consultations. So we do them. They're more of porch consultations. If you're on this Zoom, then we're more than happy to do a Zoom with you or a phone call as a form of consultation. And then if we have to meet with you for document signings, we can do that. We're trying to be COVID-free as much as possible and very careful and kind of control the environments if we can. We've done document signings where people are sitting in their cars. It's an elaborate process that involves a lot of prep and discussions beforehand, so that way everyone knows what they're doing. Another question, what if a long-term care situation arises before 5 years? Or am I saying the assets are not protected? That's exactly what I'm saying. They would not be protected, but they would be closer to being protected. So if we were 4 years and 10 months in, right, I would advise the client to find a way to private pay for that long-term care event, private pay the nursing home for 2 more months to get to 5 years. If we're at 1 year and 10 months, well, then chances are that we may need to blow up the trust and do what we call crisis planning. I'm going to leave that to my partners to discuss in their lengthy webinars, or if you want to look at one of our on-demand ones to talk about crisis planning. But the idea is, with a good, strong power of attorney, we could actually save at least about 55 cents of every dollar if we didn't get that far. Depending on the amount of money people have, theoretically, every month that you've done the trust, that the trust has been in existence, is a month where we're saving money. So, you know, I want you to go for it. Also, okay, there's another form of Medicaid that is not associated with a 5-year look-back period. That's for home care. And you can qualify for the home care in as little as 2.5 years of planning, and in some cases, no planning whatsoever. All really asset, situation, care specific. So I don't want you to say, hey, guess what I just heard? But certainly there are possibilities. So it's a simple question. If you don't get to 5 years, am I protected or not? And was it worth it? And the answer, of course, is really complicated because it depends how close we got to 5 years, what kinds of assets we have. What's our family situation? Can we move things to a spouse? Can we move things to a child who's disabled to try to save the day? Those are all possibilities. So that's all the questions. I think we're pretty close to, yeah, getting there. I appreciate you guys taking part in the webinar. I encourage you guys to look at our other webinars. You can find them again at herzoglaw.com, our seminar page. If you want to call us for a free consult with myself or any of my colleagues in any of our 4 offices or Zoom or what have you, you call us at 518-465-7581. I think that number's all over the place. We will be sending you a copy of the slides. This webinar was recorded and will be posted on our website. If you want to help go to sleep tonight, you can watch. Well, it may not be tonight, but in the future, if you're feeling like you're an insomniac, watch this and fall right asleep. Take care, guys. Nice to see you.